Have you ever watched someone realize in real time that something they thought was untouchable is suddenly out of their control? Not money, not power, not reputation, but something personal, something sacred, a relationship they believed would always remain protected. I saw that look yesterday inside a federal courtroom. It wasn't loud, it wasn't dramatic. It didn't come with shouting or anger. It came quietly, slowly, like the air had been pulled out of the room. For years, Donald Trump has faced investigations, indictments, lawsuits, hearings, and through all of it, he has usually projected the same image: defiant, confident, unmoved, criticizing prosecutors, attacking the process, walking into court like nothing could touch him. But yesterday was different. Yesterday, that image cracked, and it happened for one reason. His youngest son, Barron Trump, was called as a witness. Not a political ally, not a former employee, not a distant associate. His son is under oath inside a federal criminal trial, and everyone in that courtroom understood immediately what that meant, because cases change when evidence becomes personal. The broader case itself has been unfolding for months. Federal prosecutors working under Special Counsel Jack Smith have alleged obstruction and related offenses tied to classified materials recovered from Mar-a-Lago. According to court filings, the government claims certain documents were retained after leaving office and that there were efforts to resist or delay returning them. The defense disputes those claims entirely. They argue misunderstanding, overreach, and lawful authority. Nothing has been decided. Nothing has been proven. But the prosecution's burden is clear. They must establish intent, not just what was possessed, but what was known, what was understood, what was said behind closed doors. And that's where witnesses matter, especially witnesses who were present inside the home. Prosecutors told the court they believe Barron might have relevant observations, conversations overheard, meetings witnessed, moments that could help establish context. Not speculation, not opinion, just what he personally saw or heard. Under federal law, there is no automatic parent-child privilege. If a person has material information, they can be subpoenaed. It doesn't matter who their family is. It doesn't matter how uncomfortable it feels. Process moves forward. Trump's legal team objected aggressively. They filed emergency motions. They argued that compelling a son to testify against his father created unnecessary emotional harm. They questioned relevance. They sought to block the subpoena. But the judge reviewed the government's summary of expected testimony and ruled that it met the legal standard: relevant, material, permissible. The deposition and potentially trial testimony would proceed. That ruling set the stage for what happened next. The courtroom was packed the following morning. Media, observers, supporters, critics, everyone sensing that this wasn't just another witness. This was something different. When Barron entered, the room grew quieter than before. He walked in wearing a dark suit, tall, composed, reserved. He didn't look toward the defense table, didn't wave, didn't acknowledge anyone. He simply walked straight to the stand, raised his hand, took the oath, and sat down. From across the room, Trump watched intensely, his hands clasped tight, jaw set, the kind of look someone has when they know they cannot intervene, because any communication with a witness could be interpreted as influence. So he said nothing, he just watched. The prosecutor began simply: name, age, relationship. Barron answered calmly, measured, respectful. My father, he said, not casual, not emotional, just factual. The questioning moved to background: where he lived, when he lived there. Whether he was present at the residence during the time periods under investigation. He confirmed he had been. Then the tone shifted. The prosecutor began asking about specific moments, conversations he might have overheard, meetings he might have walked past, whether he ever heard discussions about documents or legal concerns. Barron paused before answering, carefully choosing words. He didn't speculate, he didn't guess, he repeatedly clarified only what he personally remembered. He described overhearing phone calls, fragments of conversations, mentions of legal pressure, references to investigators. At several points, defense counsel objected. Hearsay, scope, foundation. Some objections were sustained, others were overruled, standard courtroom rhythm, but each answer added another piece of context, another small detail, nothing explosive by itself, but together they painted a picture of proximity, of presence, of someone who had simply been there when things were discussed. The prosecutor then showed photographs of rooms inside the residence, storage areas, offices, boxes, asked if he recognized them. He identified locations he had seen before, matter of fact, no drama. Then came questions about whether he ever heard talk about responding to investigators or handling materials. Again, careful answers, limited, specific, only what he personally recalled. At one point, he acknowledged hearing discussions about legal risks and the stress surrounding the investigation. Nothing framed as criminal, nothing exaggerated, just atmosphere, concern, tension inside the home. But what made the moment powerful wasn't what he said. It was who was saying it, because juries view family differently. A family member rarely looks eager to testify. They don't look hostile. They don't look motivated. They look reluctant. And that reluctance often reads as credibility. Throughout it all, Trump sat at the defense table, barely moving. At first, he stared straight ahead, then down, then back at the witness stand, his breathing heavier than before, his hands gripping the edge of the table, and when certain answers were read back by the court reporter, you could see it on his face, the weight, the realization, not anger, not outrage, something closer to resignation. At one point, he covered his face briefly, just for a second, then lowered his hands. The judge eventually called a short recess, standard procedure, but when Trump stood up, he looked unsteady. Marshals approached quietly, asked if he was okay. He nodded, said nothing. When court resumed, Barron finished answering a few final questions. Then the prosecutor said, "No further questions." Defense counsel rose for cross-examination. The tone softened. They asked if he loved his father. He said yes. Asked if he wanted to harm him. He said no. Asked why he was testifying. His answer was simple: because I was subpoenaed, and I took an oath to tell the truth. No hostility, no bitterness, just obligation. And that answer carried more weight than anything else, because it suggested he wasn't there to accuse. He was there because the law required it. Nothing more, nothing less. When he stepped down and walked past the defense table, he still didn't look over. Trump followed him with his eyes the entire way, until the door closed. Then he lowered his head onto the table. Didn't speak, didn't move. For several seconds, he just stayed there. The judge had to ask if he needed a break. His attorney answered for him. "Yes, Your Honor. From a legal standpoint, the testimony is simply evidence. Another piece of the puzzle. It doesn't determine guilt. It doesn't end the case. But strategically, it matters, because it shifts the narrative from documents and timelines to human memory. And juries remember human stories more than paperwork. The trial will continue. More witnesses will come. More arguments will be made. The defense will challenge credibility, will question interpretation, will argue context. That's how trials work. But yesterday created a moment no one in that room will forget. Not because of what was proven, not because of a verdict, but because of what it represented. A father watching his son take the stand, a legal system that treats family like any other witness, and a realization, visible, unmistakable, that some parts of life can't be shielded from process, not power, not status, not history. In that courtroom, procedure didn't feel procedural, it felt personal. And sometimes that's heavier than any sentence.